Breaking. Blake Lively has zero evidence of a smear campaign, according to Wayfarer parties. Dear Judge Lyman, we write on behalf of defendants Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz at Ends With Us Movie, LLC, Jennifer Abel, Melissa Nathan, and the agency group PR, LLC, collectively the Wayfarer parties, in opposition to plaintiff Blake Lively's motion to compel. The court should not grant the relief requested. In its August 29th, 2025 order, granting in part and denying in part Lively's previous motion to compel, the court ordered the Wayfarer parties to produce documents and communications dated between December 2024, the date litigation began, and February 18th, 2025, the date Lively filed her first amended complaint. The court further ordered the Wayfarer parties to produce a privilege log of documents from that time period that were withheld on a claim of privilege. The court granted Wayfarer parties leave to submit a categorical privilege log pursuant to local rule. The Wayfarer parties did so. On September 9th, 2025, Lively requested to meet and confer about the privilege log, which occurred on September 10th, 2025. During that conference, Lively requested that the Wayfarer parties provide additional information about the basis for assertions of privilege over communications that included defendant Jed Wallace, provide additional information about the basis for assertions of privilege over communications that included Spencer Freedman and Jared Freedman, and amend their categorical privilege log to reflect the number of documents withheld within each category. In response, the Wayfarer parties informed Lively that defendants Jed Wallace and Street Relations, Inc. were represented in connection with this matter by counsel for the Wayfarer parties and pointed them to the already produced retainer agreement executed by Mr. Wallace in December 2024. The Wayfarer parties further informed Lively that Spencer Freedman and Jared Freedman were law clerks assigned to work on this litigation. Finally, the Wayfarer parties agreed to produce a categorical privilege log identifying the number of documents withheld within each category identified on the privilege log, and did so on September 15th. The Wayfarer parties then produced an amended categorical privilege log showing approximately 4,600 signal chats. The Wayfarer parties, however, alerted Lively that this number did not accurately reflect the number of signal chats, as it included each attachment as a separate document. In other words, a single signal thread that attached 5 images would be counted as 6 documents. Similarly, where multiple recipients were included in a particular signal chat, the identical document would have been collected from each of those recipients. Therefore, if 5 custodians participated in the same chat, 5 copies of that chat would be included in the total of privileged documents. Due to the abbreviated time frame in which Lively demanded an amended categorical privilege log, the Wayfarer parties were unable to provide account of the individual deduplicated signal communications withheld on the basis of privilege, a time-consuming undertaking requiring manual re-review of documents already determined to be privileged. It's a lot of time and money on legal fees just to produce duplicated documents, communications. Since producing their amended categorical privilege log, the Wayfarer parties have reviewed the documents and can confirm that once deduped, there are under 300 privileged communications during the relevant period. So not 4,600 signal chats, but under 300. Blake added almost way over 4,000. She wow, she really made it seem like they weren't doing their job in producing and they weren't cooperating with the discovery process. She made it seem like the Wayfarer parties weren't being cooperative. But she literally demanded that they produce all of these documents that they had already produced. She just wanted to be extra, extra certain that there weren't any hidden communications. Oh, which is ridiculous. You don't need over 4,000 extra messages to do the math here. The Wayfarer parties have also re-reviewed communications involving Jared Freedman and Spencer Freedman without attorneys as participants. There are 3 such documents that were withheld on privilege grounds. All 3 relate directly to the preparation of legal documents in connection with this litigation, with which Jared Freedman and Spencer Freedman were instructed by attorneys to assist. Moreover, Lively never informed the Wayfarer parties that she intended to move to compel a document by document privilege log, nor asked the Wayfarer parties their position. By failing to identify the relief she now seeks and to give the Wayfarer parties an opportunity to respond, Lively failed to meaningfully meet and confer as required by Rule 4C of the court's individual practices, and the court should deny the motion on this basis alone. See Jones v. Abel from 3 days ago, from September 6, 2025. It is right now, it's almost midnight on September 29th, 2025. This was 3 days ago. They're saying, you ruled this way 3 days ago, and so please be consistent in denying this motion. Denying motion to compel third-party deposition solely based on a failure to meet and confer. Lively not only failed to meet and confer as the court requires, but also fails to articulate any basis for requiring a document by document identification and description of the Wayfarer party's privileged signal communications. Further, although Lively has repeatedly demanded additional information with respect to the Wayfarer party's original and amended categorical privilege logs, she has failed, despite repeated requests to specify the additional information she seeks. Lively misrepresented the Wayfarer party's position by stating that the Wayfarer parties declined to provide additional information. On the contrary, the Wayfarer parties repeatedly asked Lively to specify what additional information would satisfy her demands, but have been repeatedly rebuffed. So she wasn't giving specifics as to what she needed. And then she misrepresented it to the court as Wayfarer parties not cooperating. They just weren't given fair or appropriate instruction. So Wayfarer parties produced a categorical privilege log mirroring those produced by others in this litigation. In fact, the Wayfarer parties provided more information in some instances, including by amending to specify the number of documents withheld, even though Local Rule 26.2 does not require doing so. Lively relies on her theory of an ongoing retaliation campaign against her as justification for probing into communications protected by attorney-client privilege during litigation. And this part is important. Despite never having produced any evidence that such a campaign existed either before or during this action. Are you guys getting that? That's kind of a big deal that Wayfarer just confirmed for us that Blake Lively thus far has zero evidence of a smear campaign. Okay, let that sink in. A lot of Blake Lively's supporters say that she's not showing her hand just yet. Wait for trial. We don't know what she has. Discovery is still ongoing. Deposition is still ongoing. We don't know. Let's wait to see her side. But Wayfarer just confirmed that they have seen zero evidence of a smear campaign. Okay? And they are entitled to see all of the same discovery that she does, all of the same depositions. Zero evidence of a smear campaign. And that has been my issue with this case from the very beginning. From the very beginning. Because if you go over the timeline, it doesn't add up. The math does not math. And it is extremely illogical for Lyman to allow this to keep going, especially in Blake's favor, when again, there is zero evidence of a smear campaign. And he's just allowing her to continue this fishing expedition. 107 content creators were subpoenaed for criticizing Blake Lively. Small content creators, many without access to legal resources. In fact, that is what inspired me to create this channel, because Blake Lively, she can't silence all of us, okay? And I'm just tired of seeing people like Blake Lively weaponize their power and wealth to do very similar things, okay? Same thing just happened to Jimmy Fallon, but for some reason, he's having Ryan Reynolds on his show. Anyway. Nevertheless, the Wayfarer parties are willing to provide a further amended categorical privilege log that subdivides the privileged signal communications into categories by the participants in each group of communications. If additional information about the description of those groups of communications can be provided without waiver of attorney-client privilege, the Wayfarer parties will provide it. Requiring the Wayfarer parties to do more would flout the decision in this district holding that parties need not provide a privilege log for post-litigation communications at all, let alone a document-by-document privilege log. They're calling out that they've been treated very unfairly by this court. Even by just calling out a ruling that was made 3 days ago. 3 days ago. Lively relies on her theory of an ongoing retaliation campaign against her as justification for probing into communications protected by attorney-client privilege during litigation. I don't think that's normal. Don't think that's normal. Despite having never produced any evidence that such a campaign existed either before or during this action. Anyway, I really just wanted to share the news with you all. There's another document on the docket. It's Teresa M. Troopson's declaration, basically going over how it's basically a declaration confirming that the Lively parties did not attempt to meet and confer before asking to produce certain documents, I believe. But it's basically related to what they called out in this letter to the judge about his ruling 3 days ago. So yeah, that's all for today. Tomorrow or sometime this week, I'm really hoping to go over this source of truth document that I just keep going back to throughout this case, especially given the fact that Wayfarer just confirmed that they don't have evidence of a smear campaign. They just confirmed that. The funny thing is that their motion to dismiss certain claims from last week, I think most of that was based on jurisdiction and other sort of technicalities. I don't recall if they flat out confirmed that there's just zero evidence of a smear campaign. And you know what? This week, we'll dive into why. We'll dive into exactly why that is. Because again, I've had documentation since the very beginning of this case of, why it's not possible for there to be any evidence of a smear campaign. It's not just because it's untraceable, because untraceable never actually means untraceable in the digital world. So I really want to dive into that this week, especially given these new filings, and hopefully some of these other documents will become available, because there's another declaration, selected parties, and I have no idea what that is. So maybe we'll get some insight there. Anyway, thanks for hanging out with me today. Please like the video. Please subscribe to the channel. Again, I'm new here, so you can be new here with me. That would be a lot of fun. What I like to do here is play The Sims and cancel men. Like, not seriously, but just in a general sense. Like Ryan Reynolds, he's canceled. Justin Baldoni, not canceled. You know what I mean? So please like the video, subscribe to the channel. And maybe, we can figure out how to cancel Trump together. Someday? Who knows? Thanks, guys.